Good morning. My name is Jeff Bates. I'm a judge on the Missouri Court of Appeals, Southern District, and I'm joined today by Kathy Zacharias, legal counsel for the Office of State Court Administrators. Kathy and I were part of a panel of 4 people, and the other 2 were Melinda Bentley, ethics counsel, and then David Ranson, an attorney in Springfield, that recorded a video for the Missouri Bar about expanded remote access to CaseNet. It's been a few months and there have been some updates that we wanted to share with you today. And so Kathy and I will bring you up to date on things that we know about differences. The original video was recorded on February 27th, 2023. And so today all we're going to be talking about is new information that was not available at that time. The first thing we wanted to mention to you is public access to a few kinds of documents was permitted previously under Court Operating Rule 2.04D, C, and that included liens on real estate in Chapter 429, final civil judgments except for some carve-outs, and probate orders and decrees serving as judgments. The Supreme Court just recently repealed that provision of the Court Operating Rule that was on May 23rd, 2023, and the reason is it will better facilitate the rollout of the new remote access to documents proceedings that we're going to be starting on July the 1st, because those documents were not subject to the redaction requirements that will be in place once new documents start being filed in July. There was also a provision in one of the court operating rules to phase in the remote access to documents by a schedule that was approved by MCA. That schedule is now available, and so we wanted to share that with you. It starts on July 1st, but the rollout is very narrow for the first couple of weeks. It will only affect the Supreme Court of Missouri and the 3 districts of the Court of Appeals. Starting on July the 16th, the first 11 circuits, the rollout will take place there, and then it will continue in an order over the next few months until about mid-October. And the one thing we wanted to caution you about is that rollout schedule may be halted temporarily if we run into problems with the rollout, or if the public demand is too great and it starts affecting CaseNet. So just be alert to any changes in that rollout schedule.
As we had mentioned previously, the rules require that confidential information be redacted, and then it's important to look at the source of those rules in order to determine what documents or what information should be redacted from your documents. We wanted to point out that one of the provisions that we had mentioned earlier, 509-520, that is being amended in Senate Bill 103. Senate Bill 103 was passed, truly agreed to, and finally passed. We won't know until July 14th whether the governor will sign it. And if it's signed, it goes into effect August 28th, 2023. So the language in Senate Bill 103 that's amending 509-520 will impact the information that would have to be redacted from your documents. Specifically, it's identifying more clearly financial institutions. It's added PIN numbers and passwords. It's added the full motor vehicle license number. It's added victim information, including the name, address, and other contact information of the victim. It also says includes witness information, including that name, address, and other contact information of witnesses. It also includes any other full state identification numbers, and what is a real major change would be the name, address, and date of birth of a minor, and if applicable, any next friend. It also has which is not so different. The full date of birth of any party, however, the year of birth shall be made available except for a minor. So you'll really need to take a look at that statute in order to determine what you'll have to redact going forward. And as I said, if signed, that becomes effective August 28th. The information would be provided on a confidential information filing sheet. That would be the CRIFS form that we've discussed previously. And the Supreme Court will need to make rules to administer that. I believe we mentioned before that the bar on their website has put together a resource center. One thing we wanted to point out is that there are tutorials that are available on the website on how to actually use your PDF software to redact the documents. So you may want to keep looking at the resource center and take a look at those provisions on how to use the different PDF software. There's also a page that shows you what software is available and what software actually does do redaction. So that will be available for you if you're trying to decide what information or what PDF software would be best for your office. We mentioned before that you have to provide redacted information on a confidential redacted filing information sheet, and that either has the unredacted version of the document attached to it, or that it has the information listed on with generic identifiers. And that document's going to be assigned a confidential security level. That's a 3 for those of you who are aware of the court security levels. And that security level limits access to attorneys of record and to court staff. An example of what the forms will be shown in just a second, but the SJRC approved updated the CRIFS form and updated a number of the filing information sheets to have the CRIFS form attached to it as a page, so that when you're initiating a case and if you have to provide the filing information sheet, you just provide the one document. These will be found on the Your Missouri Courts website. That's courts.mo.gov under court forms, and there's a subcategory called filing information sheets. We're expecting any day now that those forms be uploaded to the website. They're not there as of today, which is June 2nd, but please keep checking the website for the forms. One thing to note, these are mostly going to be used by your self-represented litigants, but the confidential filing information sheet for non-domestic relations, we're just showing this as an example. There's now been a checkbox at the top that says that an unredacted version of the document is attached to that, so you would not have to complete the information on identifying what was redacted. Another example is the confidential case filing information sheet criminal. So again, it has the checkbox, but it has a page 2, which would have the redacted information identifier. You would put such as defendant's social security number, and under redacted information, you would put 1, 2, 3, 4, 5, 6, 7, 8, 9 as the social security number. In addition, there is the redaction certification form. Again, for lawyers using the e-filing system, the certification will be done through the system. But if someone is not using the e-filing system, they will have to certify either through a separate document, such as this redaction certification, or certification on the document itself. So again, this document will be available on the court's website.
The last thing that we want to share with you, and it's a very important update to remote access to documents, is what we are calling the error correction process. One of the questions we received all the time in earlier presentations from lawyers is, what if I send a document in and it hasn't been sufficiently redacted? And so if the document has been accepted by the clerk, there are some other things you can do before it's actually been accepted, but if it's been accepted by the clerk, the Supreme Court, in an order dated April 2nd, 2023, added an error correction process to Court Operating Rule 2.02. This subdivision E4 basically, in a very succinct way, describes this process. If any party looks at a document that's been filed and thinks it's been insufficiently redacted, they can file a motion with the court that explains what the problem is, and that allows the clerk to automatically raise the document security for that document that's in question up to a confidential level. The court has 30 days to rule on that motion and decide whether the redaction is sufficient. And if it is insufficient, the court will order whatever party filed it to do more redaction and file a sufficiently redacted copy within a certain number of days. If it has been sufficiently redacted, the clerk will reset the security level to allow for proper public access. The State Judicial Records Committee on April 28, 2023 approved some standard forms for this error correction process. We have a standard motion to correct redaction, that's form, I think, GN 325, and there's a special docket code for this that clerks can use to know when these come in. There's also a form order to correct redaction for trial courts to use that also has its own special docket code so that clerks can keep track of these filings more easily. These should be added to the court's website very soon. They have been approved by Records Committee. There were some little tweaks that needed to be made, but as soon as that's finished, they'll be posted on the website so you can see them. Those are our updates for you, and thank you very much for watching.
So we've got a couple of questions for you guys. The first one is, when filing a pleading on CaseNet, will the e-filing system notify you of what is secured?
The electronic filing system is being modified, so when you file your document, when you pick your document category and your document type, it will indicate what security level that the document is being filed at. More information as to like screenshots will be available. Those are currently being developed.
Next question, is there any change to the secure information filing sheet that we already have to file when initiating a case?
Yes, the filing information sheets have all been modified to add the necessary components to indicate redaction. So they're going to come in two basic varieties. There are a number of these that apply to different case types, but there will be one that has a checkbox if you're simply going to attach the full unredacted document as an attachment to the CRIFs. No further redaction information has to be put on the form itself. If you are going to use generic descriptors and then add the redacted information, like on that criminal information sheet that Kathy talked about, you'll need to fill out that part of the form separately and put the indicators and the redacted information there.
I would just add that typically you're not having to file a confidential filing information sheet on a typical just civil case because the system has been creating it. I do have an understanding that perhaps in some of our courts, they've still been requiring lawyers to file that sheet, but it's actually not necessary since the system does create the confidential filing sheet. So in those instances, you would have to attach the CRIFS form if you had any information that had to be redacted from your petition.
Thank you. Will attorneys of record have access to both redacted and non-redacted documents?
Yes.
The next one's a little bit of a long one, but let's talk through judgments. What do attorneys need to file when they're filing a proposed judgment?
What I'm going to recommend is that attorneys who are asked to prepare proposed judgments for a trial judge prepare both a redacted and an unredacted version unless the judge tells you something differently. Because the court is going to need to have both versions to file, because one of the forms that needs to be filed is the full unredacted one with a higher security level that has all the relevant information in it. There needs to also be a publicly viewable version that has sufficient redaction done to it.
And then do judges sign both of those documents or just the non-redacted one?
They would probably need to sign both of them merely to indicate to the public that it's not a proposed judgment anymore, it's an actual judgment that's been signed by the judge, but the effective one is going to be the full unredacted version.
And we've had questions that have come up from the court clerks already about judgments and the idea what copy of the judgment would have to be a certified copy of the judgment.
Right.
And in most cases, it's probably the full unredacted version of the judgment that the lawyers or the parties are going to need to be certified by the clerk. So we have been working with and telling the clerks that while it will go in as a secure document, that is the version of the judgment that the parties will need to have certified.
Right, and we'll have the same issue with qualified domestic relation orders, because those have to be presented to banks, pension funds, and they'll have to have the certified full copy in order to do what they need to with that order. So
Next question, can an attorney get access to a non-redacted record from cases they were not on record for
no,
in the scope of a current case that they might need the record for?
they're going to have to enter an appearance or get that record from someone who's authorized to obtain it.
Or you can file a motion with the court to ask for
Good
a
idea.
confidential record. I mean, there is a standard motion for access to confidential records that if that's what they're needing, they could file that, and I guess upon good cause shown, the judge could grant access to the unredacted document.
Thank you. When you give clients copies of things that have been filed, are they entitled to redacted or non-redacted copies?
They're not the public.
They're not the public, and it is their case. It would be up to the lawyer's judgment and discretion as to whether there would be any reason they could not share that information. And the only thing I could think of as an example, if you're representing someone in an order of protection case, they're the respondent, the defendant, the lawyer would not be permitted to share a confidential address with the client, because the client is the one who's not supposed to know that information. So there will be exceptions, and they'll have to think carefully about that. They can't just give it to the respondent in order of protection cases because they're involved in the case.
Thank you. Are there any changes to how we handle paper documents? For example, what we serve on an adverse party?
The adverse party is going to need the unredacted version. There will be some modifications on some common things like search warrants. We are now going to generate search warrants in a 2-document format. We'll have a redacted version that will be used as the officer's return document, but there will be a confidential component that is actually served by the officer in the field, so the person being served can identify that it is a warrant relating to them or their property.
All right, the last question I have for you is, can the bar provide samples of commonly used pleadings to show what needs to be redacted?
I think the answer to that probably is going to be no, because those kinds of specific redactions apply to particular cases, and the lawyer is going to have to use his or her own judgment to decide what needs to be redacted in a particular case.